Hello again and welcome after a bit of a break. Sean has got some interesting news about that. But my name is Boaz Fisher and we have
the virtual pub.
Virtual pub. We've got Sean Spear and Angela Backhouse. Welcome everyone. We have a special guest, which is Angela. She's from Chamberlains law firm. She's got over 10 years of experience in various different subject matters around conveyancing, corporate and business transactions, commercial litigations, bankruptcy, wills, and financial services. But what I found the most interesting was that in 2017, you were awarded the Businesswoman of the Year in Canberra. How exciting was that?
Yes, it was a shock, but it was definitely an honour.
Beautiful, beautiful. Okay, so Sean, I'll get you to set the scene because you do it very well, and tell us why we're here.
No worries. So first of all, thank you for joining us. And as Buzz mentioned, we had a bit of a break, and it was a positive break. I had my third baby girl born 4 weeks ago. So apologies in advance if you hear some crying in the background, although I asked her not to do so. So thanks, Angela, for joining today. And today, well, so we wanted to, after a lot of talks and chats with a lot of executives in many workplaces, we wanted to know and talk about what's called employment relationship. And as we all know, the employment relationship is the legal link between employer and employees. It exists where a person performs work or services under certain conditions in return for the salary or any other compensation. And our questions, and when we talked with a lot of executives, we wondered when things go wrong, who is liable? What happens? Who is responsible for things not going the way they should go or the wrong direction? Who is responsible? Who is accountable when things not going as planned? So I understand that you are an expert in the area. So let's go. Cheers.
Cheers.
And I want to start with the sort of like, let's get the baseline question. What is employment law?
Employment law is basically the government's way of intervening in the relationship between an employer and employee. It's been a practice of our society for hundreds of years to pay someone, whether it's money or in other ways, for them to provide a service for you. And that's well before there were ever any laws in place to deal with that practice. And in fact, as a society, we did that for a number of years without there being any rules or regulations around that. It's only in more recent times that the government in various countries have decided to intervene in that relationship and create rules that revolve around that relationship to determine what people can and can't do when they employ someone to provide a service for them.
Okay, excellent. So let's get to the crux of the matter. So we know that the employer is responsible for everything. Now, I could be wrong there, but responsible to their employees' behavior. So the question is, if they're deceptive or they're misleading in their advice, who's liable in this case?
Look, it comes down to the employment relationship and the contracts involved and the circumstances around it. So if an employee has been given a task by the employer to go and do, and that employee then provides incorrect advice or is negligent in some way, then the normal course of events is that the person who has received that negligent advice, who has therefore gone on to suffer damage because of that, is most likely going to make a claim against the employer employer, because they're the ones who they've engaged to provide that advice, and the employer has basically just delegated that to their employee, but still has the responsibility ultimately between the employer and the client or customer who has engaged those services. So from the customer's point of view, they're going to have a claim against the employer in most circumstances.
Okay, so that's, so irrespective of what training has been provided, policies and rules and behaviours of what is deemed as acceptable. So even though they're fully aware of it, the employee never is able to step away from it. Would that be correct? So this.
Oh, sorry, both.
Responsible.
Sorry, can you repeat that last question?
So we probably.
So I was saying, based on what you just said, so go ahead there, Sean.
Yeah, so I think what Buzz means that accountability from the individual, irrespective where they understand or didn't understand what the organizations instruct.
So there's obviously going to be different outcomes depending on the specific circumstances. If an employee has been so reckless that they have gone completely outside of the rules and requirements of the employer, of which they were well aware of and trained in and that kind of thing, and essentially stepped outside of what is or should be their role as an employee, then they could potentially find themselves personally liable to that customer for the conduct that they've engaged in. The reason that often the customer or client won't necessarily pursue the employee for that is because normally they'll look at the employer as being the one who's likely to have more money to pay a claim for damages and likely an insurance policy to cover it as well, whereas the employee is going to be less likely to have the funds to compensate them. And so therefore you don't see many claims there, and as well as there being that extra hurdle that would have to be met in order to prove that the employee has been so reckless that they just completely disengaged with the requirements of their employer and went off on a completely different tangent. And that's a pretty high hurdle that the customer or client would need to satisfy. That's not to say that if a claim was made by the customer against the employer, there's a separate issue there between the employer and employee. If the employee has done something that's so significant that they've caused financial loss to their employer and they've gone outside of the rules and regulations and requirements of their role, they've not complied with the internal policies, procedures and requirements and directions, then there's definitely going to be a course of action between the employer and employee in terms of their ongoing employment, and that's going to be a separate issue.
Is the factor a major factor in that scenario? For example, if the employee did something on purpose or by accident?
That's always going to be a factor, because if they've done something intentionally, then they're probably doing that intentionally to harm either the customer or their employer, and that's going to be a very relevant factor. It could even be to the extent of it being considered fraudulent, and that becomes an even more serious matter as well.
Okay,
so I've got a question which relates to the fact that when an organisation hires new people, they often don't realise that they're bringing potentially some confidential information with them from the previous organisation. How is that dealt with typically?
So it's really a question about the relationship between the former employer and the employee, and what they are and are not permitted to do once they've left that employment and gone somewhere else. So if the former employer feels like there is an issue, the first point of call is going to be seeing whether they had anything in their contract of employment with the employee which actually prevented them or prohibited them them from either taking that information or disclosing that information to somebody else. Good employment contracts will include clauses such as confidentiality provisions, intellectual property provisions, and sometimes restraint clauses as well. And all of those clauses are going to be very relevant in those circumstances. Now, if it's to the extent that they've actually taken intellectual property from that employer and then gone and used that in their new job, there is a potential claim between the two employers for use of intellectual property, but the former employer will then need to establish that they hold intellectual property in that particular asset, whatever it is, and that comes into IP laws, which I'm not going to go into any detail because it's not an area that I cover. But there is a potential claim there, particularly if the new employer receives that IP knowing that it was used by the former employer and still goes ahead and uses that.
Yeah, Sean, you had a question. Sorry about that.
So obviously, during this session, we tried to focus on the business side that tried to protect itself against harm that potentially can come from the employees. I could say I'm a developer. I'm working with that company since it was established. I'm one of the founders, although I didn't put $1 into that. I didn't invest, but I was hired, and I helped the organization to grow. My code, my thinking, my methodologies, my creative mind brought the company to that value. Now they're letting me go. What the organization should do in such a situation where, in one hand, they know this is a very valuable, valuable in terms of knowledge employee, but also he becomes very powerful, that he's basically holding a lot of keys to the kingdom. So how organization should protect itself? In one hand, it works in one direction to empower and encourage the employee to be more creative, to contribute more, and of course it can come in the form of salary, or other incentives. But who is measuring the ideology of that person? Maybe he wants to become one of the people that will enjoy the exit, or feels that he owns part of the company. How that is managed within their employment relationship when it comes to that?
There's a number of issues there to consider, and it's interesting that you use that as an example, because we had a case very similar to that recently where we had to assist an employer exit an employee who had played a crucial role. Well, the question of how crucial they had been was an area of dispute, but the employee believed they played a crucial role in building the business and making it what it was. There's a few areas we have to look at. First, you need to look at what is the terms of the original employment agreement and any variations that have been made to that employment agreement, and that's why it's so important, even for startup businesses who don't have many employees or don't think that their business is worth much, to make sure that those agreements with their employees at the outset are addressing all of these potential issues in the future. You're setting up a business with the aim of making money and making it successful, so you have to anticipate that and put your contracts in place in anticipation of that as well. You might say, look, there's no point in putting a restraint in here because they're not going to do any damage to my business. There's not much business here. But in 5 years' time when they leave, that can be a completely different story. So your contract that you have with them is going to be completely vital to how you then deal with this going forward. There's a different element to it, which is managing the expectations of the exiting employee. If it is that you've set everything up properly and it's clear in the employment arrangement that this employee is not entitled to any interest in the business, and all they're entitled to is your standard termination payout in accordance with the legislation, whether it's redundancy or otherwise, you've got to manage the expectations of the employee. And so there could be circumstances where the employee is saying, yeah, but I contributed to all of this and I should be compensated for that. And otherwise I'm going to jump up and down and cause problems. So it then might become an issue for the employer to have a confidential discussion with them, potentially come to some sort of other resolution with them. So they maybe give them an extra little bit of a payout or something like that, on the basis that they also sign a deed of release that says, we're walking away now, we're not going to cause any issues anymore, there's going to be non-disparagement clauses to say we can't talk about this to anyone, and everyone's happy. And that can, even though it might cost the employer more than legally they're required to pay, it can give them that knowledge that this issue has now gone away, everyone's happy, and we can move on.
I'm halfway. We're halfway the session.
Well, actually, you answered the two questions, which is basically when you onboard employees and when you terminate employees. So there's got to be an expectation, but also some form of signing of a deed when they leave, of can and can't claim. What about trusted business partner, like third party, that have may have access to the organization's trusted sensitive assets and so forth? Would they be dealt in the same manner like you would do with an employee?
Are you talking about someone who's actually part of the ownership structure of the business, or someone who's a third party?
Third party contractor that provides services, consulting.
Well, that then comes down to the contract of services that you have. So in a lot of instances, and it should be the case, the service provider should have standard terms and conditions in one way or another, however that is documented and depending on what industry they're in, that actually sets out the rules and requirements of that contract. So I can use the legal profession as an example of that, because when you engage a lawyer, we are obligated under our professional conduct rules to issue a cost disclosure to you, which has certain terms and conditions, and that sets out the basis upon which you're engaging us, so that if there is a dispute and you decide you don't want to use us anymore, we're obligated not just under our professional conduct rules but also under our costs agreement to deal with that information in a particular way. And that applies throughout the board no matter what profession you're dealing with. Not all professions are governed the way that lawyers are. Some you will find don't have any sort of governing body, and then in those instances you are relying heavily on that contract for services that applies. And we do find there are a number of industries where they don't actually use any sort of contract for services, and that's where you can end up in a lot of dispute. So particularly small businesses who may have originally been in startup mode and have grown, have not necessarily adapted their terms and conditions for their customers to deal with these potential issues. And they will often come to us when it gets to a dispute situation where we have to deal with the dispute. And at the same time, they say, can you review our terms and conditions to make sure we don't have this issue again?
Okay. So we're coming to a subject.
Sorry, you go first and I'll go second.
No. You got something else that you wanted to add?
So in my previous life, I was a developer, and we gave that example. And now we all know the wolf from Wall Street. So I'll be the wolf from Pitt Street in Sydney, not New York. And I'm working in a very good and a large accounting firm. And by the years, I established a lot of good relationship with a lot of accounts. And they all trust me. We go to a lot of lunches and dinners, and they invite me to very exclusive events. And I'm very friendly with the families. I'm developing trust and relationship. Now, the account firm decided to let me go, which I'm very happy to say goodbye. But I'm taking my contacts with me because they know me. They're on my phone, they're in my head, I know them, I manage their accounts many years, and I'm moving to maybe a competitive or another company. Now, when it comes to IP, obviously stealing or taking the code of a software or any device is against the law because this is the former employee IP. But knowledge, contact, experience that I gained throughout these years, how that is protected, or should it be my IP, my personal IP?
So this is something that you should have negotiated with your employer when you started your employment. Unfortunately, it's not always something that employees think about at the time that they start. Professionals who have jumped from a few jobs and have built up that database in advance will often think of that when they're negotiating their employment contract. But others who are just starting out, who maybe don't have that build up of network yet, may not think about it. And then when they leave in 5 years' time and they have built up that network, then it becomes an issue. So again, it comes down to what's in your employment agreement. You can build into your employment agreement certain provisions. So you can have what we call a non-compete, and that effectively says that when you leave my employment, you can't go and compete with me by contacting my customers or my employees and trying to get their work. But if they come to you, at your new place, there's nothing I can do about that under a non-compete clause. So you can't go out there and try to get them to come to you, but if they just do that willingly and they find you on Google or LinkedIn or whatever, then there's nothing I can do. The other alternative is a restraint clause, and that's much more heavier, and that's going to basically prevent you from being in a business that competes with me to a certain area over a certain period of time, and whether those people come to you directly or you go to them, you just can't do that at all. Restraint clauses have been subject to a lot of litigation. The courts in general don't like them very much because they see them as actually restricting your ability to make money in a profession that you're trained in. So it's very important when you're putting a restraint clause in from an employer's perspective that restraint is actually going to be a reasonable one that can be enforced by the courts. And that's why we do recommend when you're putting restraint clauses in a contract that you get legal advice in relation to that to make sure it is going to be enforceable.
Well, I wish we could have that device for Men in Black, that whenever you leave the organization, you look at that for 3 seconds and damn, you don't have to meet again. Yeah.
I have a question. Let's actually more. Actually, I may get Sean to paint the scene, but organizations are going more and more about gathering evidence about what their employees are going to do. The question is, what is deemed as evidence? Because now with technology, you can actually capture their actions. You can see what they're doing on the screen. This has been done in so many different ways. What is deemed as evidence that you could actually take to court and say, look, he did something that we purposely or asked him not to do, and yet we've got evidence that he or she did that?
Look, it's really important.
Who's got the right?
It's important to make it clear in your policies, procedures, or even in your employment agreement that the employer has the right to control and access your emails, to keep records of certain things, and if it is that they are going to be using some sort of surveillance equipment or the ability to keep your phone records or things like that, and this all has to be in relation to company assets, so they can't give them rights over your personal phone number. But if it's a business phone number or business email, and it's set out in the policies and of the firm or the company, then they have the right to access that, and if they need to access that and use that as evidence, then it can be used. But if you haven't got that in there and you suddenly go and put a video camera up in the office and hope you can catch someone out, there's going to be significant issues there because you're in breach of privacy laws, and using that as evidence is going to be problematic.
So when we walk everywhere outside, we can see those cameras, and we don't have disclosures every step we take on our way or on the road. Please be aware that there is a camera on the next stall. If you want, stop and go back. So obviously we are being recorded all the time. So where is the fine line between being intrusive and violating privacy and protecting the organization assets?
There's a difference between the cameras that are out in the public. They're accessible by the government, and that would be used as criminal proceedings and that kind of thing. Whereas if it's to deal with an employee-employer relationship, then it's going to be very different. It's even when you go to premises that you go into a shop that has a security camera, you will always find somewhere, or you should always find somewhere in those premises, a sign that says these premises are monitored, and that's their way of letting you know you are on camera, and then you can't object to it later on if they use that as evidence. But there's a very big difference between public evidence and private evidence.
Yeah. So when it comes to business to protect themselves, and obviously when it doesn't matter whether these are everyday people, employees, or power executives, or even third-party trusted advisors or service providers, when they access the critical assets of any organization, that basically, without these assets, the organization can't work. This is the base of the business. If something happened, well, let's talk about even before something happened. What organizations should do when it comes to employment relations and communicating that to people? What should they do to protect their own business? And what security measures do you think? For example, we talked about the insurance. Every organization must have insurance in order to operate. It's a legal requirement. Sometimes it's a must-have. Sometimes you can't operate without insurance. Obviously, the insurance will compensate for certain losses. There will be some losses that insurance cannot compensate. For example, time. As you mentioned before, if my house is burnt down completely, I will get the money for the house. But during that time, I will need to find an alternative accommodation. I lost my pictures, my history, my personal assets that got burned out. No money in the world can compensate me on that. So nothing can return back the time. So what will you recommend to employers to protect their business against rogue or unintentional risky people?
Look, you can take out insurance policies for a number of things, and you can take insurance for some of those things that you want to cover. It just depends on how much money you want to spend on insurance, because I'm sure there's going to be someone out there willing to give you an insurance policy on it, but how much is it going to cost you? And I was saying before to Sean that, you can take out insurance policies to cover you for things that your employees do that cause you loss, or even if they decide to take you for unfair dismissal and things like that. There's insurance companies there that will cover you for that. That'll cover you if you get audited by the ATO. There's just a number of different things you can get, but ultimately, unless you've got lots and lots of money to just throw away, you're not going to have insurance on everything. And then that comes down to, secondly, making sure you've got the right contracts in place, whether it's internally with your staff, whether it's externally with subcontractors, or with your clients or customers, to make sure that you're protected in any way you can be contractually to deal with any potential disputes, because that's going to be your next best protection. And then thirdly, it's about how you manage the business, because just hiring someone, putting them in a position and saying do it isn't going to be enough to make sure they're going to sit there or stand there or do whatever they're doing and always act in your interests. You've really got to be managing them all the time, checking what they're doing is right, making sure they're properly trained, make sure they're aware of the processes and procedures you have in place, not just put them in a folder somewhere, but training them on them all the time. So that means you having to work actively in the business to make sure that those things are happening. And I think between all those three things, that's your best way of protecting yourself.
All right. how do organizations protect themselves when there is maybe an outside influence, like acquisitions or merger acquisitions, restructuring, and so forth, so takeovers? So should there be, is there somewhere that you can build in that sort of contract, an employee-employee contract? Can an employee file for grievance for something that, it wasn't expected, if there was, a merger that took place and they missed out? Or
the employer never consult the employee before they do an acquisition or a merge, because usually it's kept in secret for many months during the negotiations and the due diligence if someone wants to buy the organization. Now, what happened when the employees find it and it's basically announced to everybody? Or you can imagine that will be a lot of people that will think, am I going to be redundant? What's going with my position? We're going to merge with another organization, and they have already an accountant, or they have already support people, and I'm support. Maybe I will be fired. So, and that of course create and maybe an aggression from the employees, or frustration that can lead to stupid stuff that can put the risk organization risk. So, what will you say to these organizations?
Well, I would say that that needs to be part of their project planning when they are implementing the restructure. Change management is something that is crucial with these kind of transactions, and you have to manage the expectations of all the stakeholders, which includes your employees, not just your customers, not just the investors. It's everybody, and your employees play such a crucial role in the success of your business that you need to make sure they're along for the ride. Now, obviously, due to confidentiality requirements, you can't always tell them what's going on until things are signed on the dotted line, but then there needs to be a plan in place for how this is going to be communicated to the employees, and how you're going to speak to them, not just as a group, but on a one-on-one basis, how you're going to make yourself available for answering questions and dealing with issues. I mean, it can depend on the type of business. You could have 10 employees or you could have 200, and that's going to dictate how you deal with it. Because in a lot of these circumstances, yes, there can be redundancies resulting in those kind of transactions. That's normally one of the things that companies will look at when they've done a restructure, is, who is no longer needed. And so you have to be upfront with your staff if that's going to be the case, and say, we'll be speaking to you individually, answering your questions, and if your role could potentially be made redundant, we'll be having those discussions with you. And that's an obligation anyway. If you are going to make a position redundant, you have to consult with the employee, talk about whether there's other alternative positions for them in the company, and let them have an opportunity to have their say about their position before you decide whether that role will be redundant. And if you follow all those rules, then you can do a genuine redundancy, and provided you pay them out the amount that they're required to be paid, then you followed all of the rules, and then you've got to maintain a communication with the ones who have stayed to make sure they understand why you have made the decisions you've made.
Angela, I have 2 statement questions for you. Very tough. One, will you say that people are the biggest asset to an organization?
Yes, I would, definitely.
Would you say that people are the biggest risk to organization?
Absolutely.
Where was the case? Angela, just in closing, are there any questions that we should have asked you but haven't? Is there any last words?
I could talk about employment law for hours, and there's so many different topics when it comes to employment law. Every case that walks through my door is different, and you never have the same case and the same issues, but there are so many issues that arise with employment law. You're not only dealing with disgruntled employees who have been dismissed, but you're dealing with employment contracts at the happy time when they're about to start a job, or you're dealing with assisting clients with preparing or improving their precedents and their policies and procedures. I think the one thing that I really find is the businesses that have gone through a growth phase, and they're the ones who really need to be paying attention to their employment documents, because we find so often that small businesses start out, they don't put a lot of thought into their employment documents. They maybe pull something from the web or something cheap and easy, and then they suddenly grow and they've got 20, 30, 40 employees, and they start having issues with their employees, and that's when they come to us saying, oh no, we've got these problems. Where if they can think about that earlier on, it's going to minimise the amount of time they have to spend dealing with these issues down the track.
Cool. Sean, I'll get you to wrap up, but I'll also ask you the key question, which is, what is your number one takeaway from the conversation that we've had so far?
I think that Angela concluded. Oh, you're asking me?
Oh, sorry.
Yes.
I thought you were asking me.
Oh, but you can go Angela afterwards.
I would say that Angela wrapped it up that so well that basically my takeaway is, when it comes to employment relationship, we need a lawyer. You can't just download documents from the internet. It will work if you employ yourself, but not if you employ others. So that's for sure. There are so many aspects and bad implications if things goes bad, especially when the legal side. I think in general, we understand that organizations, where people are the biggest asset to organizations, and people should be managed and treated fair, and also with a lot of respect, but with a lot of cautious. And when everything starts with roses, you don't worry about the roses. You worry about the fire when things stop. So when people leave the organization, hopefully in many cases, they say mutual goodbye and move to the next challenge. But there are some cases where things go bad, and prior to saying goodbye, employees, they try to harm the organization or take what they think they should deserve. So obviously the legal document and the legal policies should be in place. Awareness is a must-have. Employees must know what could be the consequences of their actions. Organization must know the consequences of their employees or other dependencies' actions, and they need to expect the worst, or hope for the best, but expect the worst and be prepared for the worst. Evidence, it's a good and important part. If something goes wrong, you need to know what happened. You want to pinpoint that incident or event and be able to remediate it properly. That's my takeaway.
Cool. Angela, any last words?
That's a good summary, Sean. I think when it comes to the employment relationship, it's partially about managing relationships and communication, and it's partially about making sure you've got the contracts and documentation right. And if you can get a good combination of both of those, then you're going to be minimising the amount of employment problems you have.
Angela, I've got one last question for you. A very difficult question. If someone watching this video wants to get in contact with you, how do they do that? What's the best way?
Yeah, best way is to go onto our website, www.chamberlains.com.au. We've even got, you can ask questions on our website and get responses pretty quickly there. And you'll find all of my contact details on there as well.
Excellent. So you heard it. Go on to chamberlains.com.au website, and you can find all the information and contact details of the right people to contact with. Sean, last words, because I know you like to.
As always, this session was being recorded, and it will be uploaded to our SABASAI YouTube channel. So please use the comments below to comment and to ask questions. You can reach out to us for any question, and we will refer you to Chamberlain for any legal advice. So thank you all. Thank you.
Thanks. Thanks for having me.
Thanks, Angela. Much appreciated for you coming along. It's been a great pleasure. Thanks, Sean, again. And thanks for those people who are watching and those who will be watching. Good, guys.